Tort law protects people from harms which result from the wrongful conduct of others. While we usually associate torts claims with harms to people or property, the law also recognizes emotional or psychological harm as a distinct form of injury. This recognition was a result of historical development, as society increasingly understood the severity and long-lasting consequences of mental injury. Under the traditional common law, damages for mental harms were only recoverable as part of torts like assault, battery, or false imprisonment. Plaintiffs could include emotional distress as an additional harm if he or she also suffered physical injury or the threat of physical injury. Eventually, the courts recognized that the infliction of psychological injury was its own independent cause of action, even without any accompanying harm to a person or property. Today, most jurisdictions recognize two torts for emotional harm: the intentional infliction of emotional distress and the negligent infliction of emotional distress. We'll start with intentional infliction of emotional distress. Certain kinds of behavior under specific conditions can be deeply offensive and psychologically damaging to other people, even if there's no threat of physical harm. For example, a practical joker who thinks it would be funny to tell someone that an accident has caused serious injury or death to a family member does not necessarily cause a physical injury, yet the law holds the prankster liable for the devastating psychological impact of such a cruel joke. Since the definition of offensive conduct is subjective by its very nature, the courts have set high standards to make out a claim for intentional infliction of emotional distress. To be successful, the plaintiff must show that the defendant intentionally or recklessly engaged in extreme and outrageous conduct which caused severe emotional distress to another person. Let's take these elements one at a time. First, the conduct must be intentional or reckless. Someone can be liable for inflicting emotional distress if he or she intended to cause distress or unreasonably disregarded a high risk that the distress would occur. The key question in emotional distress cases is whether the defendant's conduct was extreme and outrageous. This is a subjective determination and must be decided on a case-by-case basis. The most widely accepted standard is conduct that is so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized society. An action which would lead an average member of the community to exclaim, "Outrageous!" One actual case in which the court found conduct to be extreme and outrageous is comparable to the example mentioned earlier. A regular customer at a pub decided to frighten the pub owner's wife, whose husband had gone away for the day. As a joke, he told her that her husband had been in a terrible accident and had broken both legs, and encouraged her to go be with her husband. In response, she vomited and suffered a violent shock to her nervous system, leading to weeks of suffering and incapacity requiring medical attention. Other examples include a defendant who made repeated late-night harassing calls to the plaintiff to collect a debt, causing her to suffer a heart attack, and a meter reader who aggressively demanded entry into an apartment where a pregnant woman was bedridden, causing her to miscarry. In one case, a woman brought a successful case for emotional harm against the estate of a man who was a guest in her home who committed suicide in her kitchen. The court found that the defendant's conduct was outrageous and reckless disregard for the risk of causing emotional distress to his host, who suffered nervous shock when she found the corpse and a kitchen knife in a pool of blood. As these cases suggest, the court will look at the specific circumstances of the case and any relationship between the plaintiff and the defendant to determine whether the conduct was outrageous. The final element is showing that the plaintiff suffered severe emotional distress. A brief period of unhappiness or humiliation is not sufficient. In one case, a supervisor had repeatedly and outrageously publicly shamed an employee with a speech impediment over the course of many months. However, since the only harm the employee claimed was a feeling of being shaken up and wanting to go into a hole and hide, the court ruled that the psychological injury was not severe enough. So there's a substantial burden on the plaintiff to show significant and lasting psychological impact. At the same time, most jurisdictions have abandoned an older requirement for the plaintiff to demonstrate that the psychological harm led to observable physical symptoms. Those are no longer necessary. A special case involving intentional infliction of emotional distress is the case of bystanders. Normally, a defendant can only be held liable for emotional distress when he or she intended to cause the distress to a particular person. If a school principal, for example, verbally abuses a student in an outrageous way, the student's friend cannot sue for emotional distress since she was not the target of the conduct. However, the law recognizes an exception in the case of immediate family. If the defendant intentionally injures someone when the victim's family member is watching, the relative can recover for the emotional injury suffered from witnessing the injury, if the defendant knew that the family member was present. For example, someone who attacks a father in front of a son can be held liable both for the physical injury to the father as well as the psychological trauma suffered by the son. Some authorities even allow recovery for emotional distress in cases where the bystander is a stranger if he or she is present and witnesses an act of violence directed against another and suffers a physical injury as a result. Under this rule, for example, someone who shoots another person in public may be held liable for intentionally inflicting emotional distress on all who are present and witness the shooting and become physically ill as a result. In addition to the tort of intentional infliction of emotional distress, most jurisdictions allow recovery for emotional harm under a theory of negligence. This means that even where there's no intent to harm or reckless disregard for the risk, someone who's suffered severe mental harm can seek to recover damages caused by someone else's negligent conduct. As a negligence-based cause of action, the courts will determine whether the defendant breached a duty of care to the plaintiff, causing emotional distress. There are two main questions the court will ask to decide a claim of negligent infliction of emotional distress. First, has the plaintiff demonstrated that he or she has suffered severe emotional injury? Since claims of psychological injury can be subjective, many jurisdictions require that the mental harm be accompanied by physical symptoms, such as nausea, headache, or any other physical manifestation of the mental trauma. However, the modern trend is to permit recovery even without any physical symptoms. The second question the courts will ask is how closely tied to the plaintiff's injury is the defendant's negligent conduct. Under the old rule, there could be no recovery unless the defendant's conduct led to some direct impact on the plaintiff. Today, the impact rule has been rejected in favor of a zone of danger test. If the plaintiff was in direct danger of physical harm from the defendant's negligent behavior, then the plaintiff can seek damages for mental harms suffered as a result. Typical cases are car accidents due to negligent driving. Take the case of a driver who runs through a red light while texting and crashes into oncoming traffic. A pedestrian who narrowly misses being hit by flying shrapnel can sue the driver for the mental injuries suffered from being so close to physical injury. The determining factor here is whether the plaintiff was at immediate risk of physical harm. Some states, in fact, don't have any special rules for negligent infliction of emotional distress. Instead, they use the standard foreseeability tests that are applicable in all negligence cases, which asks whether the harm was reasonably foreseeable as a result of the defendant's conduct. As with intentional infliction of emotional distress, some courts will recognize a negligence claim for emotional harm caused by witnessing harm to a family member. Let's return to our car accident example, but change the circumstances. In this scenario, the piece of shrapnel misses the pedestrian, but hits her sister. We'll call her Sarah, who is walking next to her, causing serious injury. The pedestrian suffers severe and long-lasting trauma as a result of seeing her sister maimed and mutilated by shards of metal, and watching as Sarah writhed in agony in the middle of the street. In this case, the pedestrian can seek recovery because she herself was in the zone of danger and suffered distress from seeing a close family member seriously hurt. A minority of states have gone even further and do not require that the plaintiff even be in the zone of danger. In a well-known case from California, a mother who saw her daughter run over by a negligent driver while she was standing a few feet away sued for negligent infliction of emotional distress. The court ruled that even though the mother herself was on the sidewalk and not in serious danger, that fact should not prevent her from recovering damages for her suffering. Rather than requiring a plaintiff to be in the zone of danger, the court ruled that being present at the scene and witnessing injury to a family member was enough. It should also be noted that not all negligent infliction of emotional distress cases involve any violence or danger. In Mullion versus Kaiser Foundation Hospitals, doctor mistakenly diagnosed a patient with syphilis. This led the patient to suspect that her husband was conducting an extramarital affair, ultimately causing the breakup of their marriage. When it was revealed that the diagnosis was wrong, the patient's husband sued the hospital on the grounds of negligent infliction of emotional distress. The court ruled that the risk of emotional harm to the husband from the misdiagnosis was foreseeable and thus held the hospital liable. As society has increased its awareness of the devastating impact of emotional and mental harm, remedies available for cases in which emotional distress was inflicted have increased, to the point where today remedies for these injuries are practically on par with remedies available for cases in which physical injuries result.